rewarding people for being here on time. Hello, everybody. My name is TJ Scott. I am a Minnesota estate planning attorney. I work in my own law firm, the Law Office of Timothy J. Scott, and I'm really happy to be with you here tonight. We're going to be talking about estate planning for family harmony, and there's going to be a theme throughout this presentation here tonight. We are in the season of giving, or we're nearly in the season of giving here. And whether you celebrate Christmas or Hanukkah, or whether you are just a giving person who loves those around you, I want us to be focused on giving, and I want us to be focused on the gift that we can make our life be, and the planning that can be such a gift to the people that we love, and especially when we can deliver on family harmony and keeping peace in the family. So those are our focuses today, and I want to encourage you, now that you're here with me, give yourself this time that you've already set aside. You signed up for this presentation. You may have had this, this may have been an area of interest that you've been thinking about for a while. Whatever the case, even if you've been interested in it for a while, trying to gain information, or if you just decided on a whim, this looks like somebody I could listen to for a little bit about a topic that sounds kind of interesting, I want to encourage you, turn off any distractions. Give yourself this time. I always say your future self is going to be glad that you took this time to learn. And I want you to stay with me all the way through the end. It is an hour-long presentation. I'm going to try and stick really closely to that hour, which is why we got started right here at 7 o'clock. But I want you to stay with me through the end because there are a few gifts that I want to give you at that time. The first gift is a free virtual one-on-one meeting with me where we can talk about the things you have and the people you love and how you can protect them. The second gift is a bonus to make it even easier to get a personalized and tailored estate plan in place for the people that you love. Before we get too far into the presentation here, I'm going to try something. I'm going to try to pop up a poll and see if I can ask you a question. And that question is, what are you hoping to learn here today? Maybe you've done an online or do-it-yourself will, and you're wondering if that is going to cover you and if it's going to keep your family out of court and conflict. Or maybe you haven't written an estate plan, or you wrote an estate plan, but it's been a long time and you're curious, or do estate plans need to be updated? Or maybe you're just gathering information. What do I need to know about estate planning? What are the important things that I need to cover? Or maybe you know that court and conflict is often attached to someone passing away or getting sick, and you're looking for ways to keep the peace, to keep the family harmony. That's really going to be our a key focus of us here today, is how we can keep that peace. Or maybe you're concerned. Maybe you know writing an estate plan means you may have to work with an attorney, and it's making you concerned about what the cost might be in order to write an estate plan. Let me tell you, there's no wrong answer here. These are all important things and important things to understand. And we are going to cover these things today. If there's something more particular that you want to ask me, if there's something more specific, there are a couple of ways to do that. There's a chat function and a Q&A function. The chat function will allow you to chat with everyone if you wish to, or you can chat directly at me as a host and panelist. There's also a Q&A function that will allow you to ask me questions directly that I will answer during the course of this presentation. And in that Q&A function, if anonymity is important to you, there's a way to keep your name anonymous so that nobody will see the question that you've asked. So if anonymity is important to you, use that Q&A function. If you're okay with people knowing that you're the one asking the question, and trust me, if you have the question, it's likely that other people here in this presentation also have the question. Go ahead and use the chat function, either to chat directly at me or to include everybody in the conversation by chatting at everyone. But just be attentive to that. I really appreciate everybody sharing with me through that poll. That was a fantastic response. I'm seeing a smattering of different interests. And like I say, we're going to cover all of these topics during the course of our conversation here today. So thank you for being engaged. Thanks for answering the poll. Let me tell you, you are in the right place here tonight. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you've done an online or DIY will, but you're not sure if it's going to work. You're in the right place if you're nervous about how much this is going to cost. In fact, I'm going to share exact numbers with you about what you can expect writing an estate plan to cost. But the reality is this: estate planning isn't about us. It's about the people that we love. And this really occurred to my wife and I recently when we were updating our estate plan and writing that estate plan. The estate plan wasn't a way that we were going to enrich ourselves. It wasn't like starting a business or investing in an asset. It wasn't going to grow and gain value for us. But it was a gift that we were giving to our kids in order to make sure that they were taken care of in the case that something happened to us. We were going to keep the family harmony, keep the family peace, keep our family out of court and conflict in order to ensure that our family stayed intact, stayed together, and was able to support one another. Again, really a gift that we were giving to them. And that's the way to think about estate planning. So, what are we going to cover here tonight? We're going to talk about a lot of things. We're going to cover a lot of ground. I have a lot of information to share with you. I know that estate planning can be a scary topic. We're talking about situations that are sad, unfortunate, but they're situations that we have to face. All of us, someday, all of us are going to pass away. That's just the reality. And we can face that if we are educated, if we are empowered to make decisions and write a plan in order to have the power over that and have the power over that reality. That's how we should face it. We know it's a reality, but we can take control. And that's what I want to give you today. I want to empower you through the education, through the information that I'm going to be sharing with you, and empower you to make the next step so that you can really take control and make sure that you are leaving the best gift for your family. So, we're going to be talking today about what is an estate plan. We're going to be talking a little bit about guardianship for minor children. And here I have another poll that I'm going to ask just to find out how many of you have minor children. It will affect how much time we spend in that conversation. Minor children meaning children under the age of 18. We're also going to talk about healthcare decisions and who can make healthcare decisions for you and what those healthcare decisions should look like. We're going to talk about who naturally receives from your estate and how you can make changes to that. We're also going to talk about avoiding court and conflict. And that's especially important as we keep this lens in mind, the lens of keeping family harmony, and making sure that we are avoiding unnecessary court and conflict in our family. I'm seeing a smattering. It looks like most people do not have minor children, and so we'll only touch on that point as briefly as we can. But it's so important that I feel the need to touch on it at least a little bit. And if any of you know anybody, have any family members who do have minor children, hopefully this will be some good information that you can share with them. Really, tonight, we're focused on a question. How can we leave a legacy that's a gift to the people that we love? That word again, gift. And I want that to be our focus. I want that to be our intention. And because we can leave a gift to the people that we love after we're gone. Before we jump in too deeply, I want to tell you just a little bit about myself. This is me with my family. Again, my name is TJ Scott. My wife's name is Tobin, and we have 5 kids. We live in Bloomington, Minnesota. We are homeschooling those kids right now, which is a great blessing for us. A little bit about my story as an attorney. I graduated from the University of St. Thomas School of Law in 2012. I worked really hard in law school and graduated magna cum laude. It was on law review, things that typically set you up for a job in big law, working downtown, something like, uh, 60 or 80 hours a week. But something really substantial, something really important happened to me the very day after I commenced from law school. And that's that my son was born. My first child was born. And having that son born the day after I commenced from law school really helped to clarify some of my wishes. I wanted to work in an area of the law where I knew that I could serve people. I wanted to be focused on giving value to my clients, and I was really lucky. I found an estate planning law firm where I worked under somebody who had been writing estate planning documents for something like 35 years. She was able to teach me how to write really great documents and also that a plan doesn't end at the four corners of the document. That in order to make sure that your estate plan works the way that you want it to, there's additional guidance, additional accompaniment that really needs to happen, really a lifetime of guidance. And I learned that, and that's what I deliver on through my firm every day. So, what is an estate plan? What am I talking about here? A lot of times when people hear estate plan, people think, oh, you're talking about a will, or you're talking about maybe a few documents, and that's what you're talking about. Really, an estate plan is kind of an umbrella term that covers a lot of things. An estate plan is a plan for your person, your assets, and those you care for in the case that you become incapacitated or for when you pass away. Again, it's a reality. We're all going to pass away someday, and we all need to have a plan in place for that eventuality. Some of us may become incapacitated either through something like an accident that puts us into a coma or from something like Alzheimer's dementia that causes us to no longer be able to have the autonomy to be able to make decisions the way that we want to. In those less than ideal situations, when our family is hurt, when our family is grieving, we want to have a plan in place. We want to have a plan in place for us, for our person. We want to have a plan in place for our assets. And we want to have a plan in place for the people that we love in order to make sure that things are taken care of and that we are able to avoid court and conflict, keep that family harmony, so that there is peace with the people that we love. So let me ask you another poll question here. I think this is going to be the last question that I ask. After hearing that description of what an estate plan is, do you have an estate plan? And I'm seeing a smattering of yes, a smattering of no. It seems like the results, the participants at least that are jumping in quickly here, are mostly saying no, that they haven't written an estate plan yet. And I'm not too surprised to hear that. In fact, the numbers bear out what a lot of polling, what a lot of information publicly available says, and that's that something like 68% of Americans have not written a will, have not written an estate plan. But a surprise for you that you may not have been aware of is that actually we all have an estate plan that has been written for us. If we haven't written that plan, Minnesota has written a default plan for us. And I want you to know this. Minnesota's plan generally is go to court. Minnesota's plan is generally if we don't have clarity, if we don't have perfect, crystal clear intentions shown, go to court and have a court decide what's going to happen. But here are some estate planning elements as well that I have listed. Things like a trust, a will, healthcare directive, power of attorney, memorial instructions, beneficiary designations, and guardianship nominations are elements or tools that we have in order to construct an estate plan. And they're tools that I use every day in order to make sure that my clients leave a legacy, leave a gift of love to the people that are coming after them. So I said that I was going to talk about this, but briefly, for those of you with minor children, it is very important that you write an estate plan. You know what is in the best interests of your child. But without an estate plan written, a judge is going to have to use their best judgment to decide what is in the best interest of your child. And if the judge decides that the best long-term guardian is going to be Uncle Larry, or the best long-term guardian is going to be Aunt Sally, then the judge can order that to be the case if something has happened to you. Again, you know what's in the best interest of your child, and you know what would help that child to thrive and what would be unacceptable. But if something happens to you, it's important to be aware that judges have a rubric that they are going to follow in order to decide what's going to be in the best interest of the child. And that can be a really challenging thing. I see somebody asking a question here. I think it's going back to this slide right here. What about a transfer on death deed instead of a will or trust? And that's a fantastic question. We'll talk a little bit about transfer on death deeds in just a little bit here. I would kind of classify them under beneficiary designations. It's not truly a beneficiary designation, but a transfer on death deed operates similarly for the home. And yes, a transfer on death deed is a fantastic tool in an estate plan if it has the right use case. So that's a great question. We talked a little bit about long-term guardianship and how the judge is going to make that decision. Short-term guardianship, who can the children stay with while long-term guardianship is figured out, is also important. The default, if the police show up and the kids don't have someone clearly documented that they can go and stay with, is that the kids would go and stay with Child Protective Services. And as a parent, I know that I don't want my kids to go and stay with Child Protective Services, which is why I made sure to write short-term guardianship documents that will take care of the kids in the case that I need somebody to step in immediately and for the short term. Let's move on and let's talk about healthcare and healthcare decisions. Again, there's a default here. And the default, if you haven't taken a step and written the provisions that you want regarding your healthcare, the healthcare agent and the healthcare decisions that you want made on your behalf, there's a court process that happens called guardianship of the person. And you may recognize this individual on this slide here. Her name is Terri Schiavo, and she has a very famous guardianship case that came up through the Florida courts with petitions all the way to the United States Supreme Court in order to decide who was going to get to make healthcare decisions for Terri. Terri when she was a young woman, suffered a cardiac event and was left in a vegetative state. She had a feeding tube, artificial nutrition that was being provided to her. Her husband wanted to remove that life-sustaining measure, that life-sustaining nutrition and hydration. Her parents wanted to keep the life-sustaining nutrition and hydration going. Through that series of court cases, it was eventually decided that the husband had the right to say the feeding tube was removed, and Terri passed away about 2 weeks after that decision was made. That decision, it was again made in something like the mid 2000s, and it really had a ripple effect across all of the United States. I can't imagine the conflict that Terri's parents and Terri's husband must have had between them. But I can tell you there was conflict between lots of families and lots of people all throughout the United States watching Terri's story and weighing in about what it is that they would want. The good news is you can decide. You can give your family the gift of communicating the person that you want making healthcare decisions and exactly what wishes you would have for life-sustaining treatment if you were in a similar situation to Terri's. And the way that you do that is by creating a document called a healthcare directive. That's one of the documents that has a really pivotal role in an estate plan to help avoid conflict, to help keep family harmony. Let's talk about the assets, and let's talk about the things that you have. If you don't have a plan in place, there is a default that is written by the state of Minnesota about where your assets go. This includes things like financial assets, things like your home, vehicles, personal property. Everything that you have, there is a default about where it goes. Oftentimes, we step in and write what's called a beneficiary designation on things like retirement accounts and life insurance. But if we don't have that beneficiary designation made, or for other assets like our home, personal property, vehicles, bank accounts, brokerage accounts, there's a default that the state of Minnesota gives us. And the default is this. Number one, the state understands that we would probably want our spouse to receive if we're married. If we do not have a spouse, or if our spouse has predeceased us, then the state understands that we probably want our assets to go down to our kids or our grandkids or great grandkids, lineal descendants of us if something happens to us. If it doesn't find any lineal descendants and there's no spouse, then we go up to your parents' level and kind of cascade down through a waterfall. If your parents have predeceased you, then it goes to your siblings or nieces and nephews, grandnieces and nephews. It even goes farther than that and goes to another level, to your grandparents' level, through your aunts and uncles, first cousins, even through your great grandparents' level. So there's kind of a cascading effect that the state follows in order to decide where your assets should go. But the reality is this. We know better than the state of Minnesota where our assets should go. Yes, maybe we want to provide for our kids, or maybe our nieces and nephews are important to us and we want to make sure that they're taken care of if something happens to us. Or maybe we want to leave assets to our church if we are pure people of faith. Or maybe we want to leave assets to nonprofits that are important to us. Maybe there are friends that we want to include in our estate plan. Friends, churches, nonprofits are never considered part of the default giving options that the state provides us. There's just no provision for charity or for churches or for our friends in the way that the state typically handles the default of where our assets go. But that doesn't have to be the case. Again, you can take control and you can specify exactly where the assets should go in order to make sure that you leave a legacy that's meaningful to you. Equally important to the what or to the where your assets go is how they make it to the people that you want to receive. Again, Minnesota has a default about where the assets are going to go. Minnesota also has a default to the procedure about how things are going to go. They have a procedure for who gets to make healthcare decisions. We talked about that, the procedure called guardianship. They have a procedure for if we become incapacitated and we need somebody to make financial decisions for us. That process is called conservatorship, another court case. After we've passed away, there's another court case that can happen called probate. All of these situations, anytime court is involved, you can expect for there to be conflict. The United States legal system is a litigious system. It's intended to have parties on either side who make arguments against each other. And so that pits a son against a daughter. The person who believes that equal distribution should be made for mom and dad's estate versus the person who thinks that unequal distribution should be made. The person who thinks that mom or dad would want a feeding tube versus the person who doesn't want mom or dad to have a feeding tube. Again, our court system asks people to choose a side and to make arguments, and that's naturally rife for conflict and rife for problems. That default of probate has some especially jarring things, some especially negative things. Number one, it takes a really long time to get through that probate court here in Minnesota. The purpose of probate is to put an agent in place called an executor or a personal representative who's going to stand in your shoes and carry out your wishes after you're gone. But the process that they have to go through takes a really long time to get that person in place, and especially to get that person the full authority and the full control over your estate that you want them to have. Typically, it takes at least 6 months here in Minnesota. More often, it's something like 12 months or 18 months to get through the probate process. Probate's also a costly process, costing something like 3 to 6% of the gross value of the assets that are going through the estate. And that's because there are different fees and different costs that accrue as you're going through the process. Things like attorney's fees, court filing fees, bond premiums, creditors need to get paid. There are appraisal fees, executor fees, all these different fees that add up to something like 3 to 6% of the gross value of the estate. And let me give you an example of what that means. For example, if the only asset that you have is a home that's worth $400,000, and I understand to some of us that's a pretty nice home, to some of us that sounds about right. A home that's worth $400,000. Well, an estimate for what probate would cost to put that house through the probate process would start, a 3% estimate would be about $12,000, or a 6,000 or 6% estimate would be something like $24,000. And I think probably if that was the only asset that was going through probate, you'd probably be looking at costs on the higher end of that scale. Maybe something like 20,000, maybe something like $24,000 in order to get that home through probate. It is costly, it's expensive, and it's unnecessary to take all that time. Probate is also public, and this is the last will and testament of John F. Kennedy, our president. And interestingly, this will had to be admitted to the probate court, and the court believes that making things public, making things transparent, serves the best interests of the community, of the public at large. And so that's how I was able to access JFK's last will and testament, which actually shows that not everything went to his wife Jackie Kennedy, that there was an immediate gift of 25,000, including one half of the remainder, but all of the other assets that JFK had actually ended up going to his kids and their issue. Not everything ended up going to Jackie Kennedy, which is a little surprising, I think, to a lot of people. Here's an important point. Court is optional. Court is not something that your family has to go through. And there are great ways that we can sidestep and avoid the court procedures that I was just talking about. For that procedure called guardianship, you can write a healthcare directive, again, that names a healthcare agent and the specific wishes that you have regarding your healthcare to make sure that those are carried out. In order to avoid the process called conservatorship, we can write a power of attorney to name an agent and to name the financial, legal, and tax powers that we want to give to that person to make sure that they are able to carry out our wishes regarding our finances, legal and tax matters, if anything happens to us. Something you may not be aware of, though, a will does not avoid probate. A will actually requires probate in order to be administered, in order to actually have its effect. But there are ways to avoid probate. Probate is optional, and one great way to avoid probate is by fully funding a revocable living trust. I'm going to talk about these out of order, though. I'm going to talk first about things like beneficiary designations and transfer on death deeds that one of our fellow attendees had talked about a little bit before. Beneficiary designations are a great way to avoid probate. And oftentimes we see those beneficiary designations on things like retirement accounts and like life insurance. It's really natural. A lot of times they won't even let you set up a retirement account without actually having beneficiaries listed that would receive that retirement account or that life insurance policy if something happened to you. A transfer on death deed is like adding a beneficiary designation to your home. It says that after I pass away, my home is automatically going to go to the person that I have listed, the grantee beneficiary that I have listed on that home. And it's very easy for people in that situation to step into your shoes and collect the home if after something has happened to you. Um, However, there are some drawbacks with beneficiary designations and transfer on death deeds. I always caution people against writing a transfer on death deed if they're going to have more than two grantee beneficiaries. And the reason is the grantee beneficiaries on a transfer on death deed truly receive the property, they truly receive the home. And then there's a question. What are we going to do with this home? And I have seen families fall into conflict and be torn apart by this decision more times than you would want to know. In particular, I remember a family where a home was left to three children, and the youngest child wanted to sell that home. The oldest wanted to keep the home and have it be a property that they could come back to and visit from time to time so that they could, relive memories in this town. And the middle child thought that it would be good to rent that property out and collect rental income. The three kids never could agree on what to have happen. And I've seen that property. I've visited that property. Unfortunately, now the windows are broken out and there's grass growing in the living room. Nobody stepped up. Nobody took care of the property, and it ended up being left to disrepair because nobody could agree about what should happen. So caution about that transfer on death deed. But something important to know is that probate is optional. Probate's only required if you have real estate in your name that doesn't pass by joint ownership or transfer on death deed at your death, or assets that exceed $75,000 that again don't pass by joint ownership, beneficiary designation, or some kind of transfer on death designation. So those are the thresholds, and especially so again, no real estate in your name and no assets greater than $75,000, which is why a lot of times we'll use what's called a revocable living trust to avoid probate. And a revocable living trust is essentially this. It's an agreement between two parties. It's really an agreement that you're writing with yourself during your lifetime, where you have property and you entrust that property to yourself acting as a trustee. So you transfer things using things like a quitclaim deed to put your home into your revocable trust by making beneficiary changes on things like retirement accounts and life insurance, by changing title on things like bank accounts and brokerage accounts and stock or business ownership that you might have, and by assigning or bill of saling things like a car or personal property into the trust, you're able to get the assets that are actually in your personal name down below $75,000 with all real estate held in a revocable living trust. And you're able to fully avoid probate. And by writing that revocable living trust, we can make it really specific and we can make it contemplate a lot of different potential situations. For example, if you want to leave all of your assets to your children, great. You can do that through things like beneficiary designations or through things like transfer on death deed. However, it's very difficult using beneficiary designations or transfer on death deeds to plan for what would happen if one of your children predecease you. And unfortunately, this is something that happens every day, that we see children who don't survive their parents, and now we need to figure out what it is that we're supposed to do with those assets because that gift to the child has now failed. If we write the provisions into a revocable living trust, we can be really specific about what you want to have happen there. If your child doesn't survive you, do we want your other siblings to receive, or your other kids, their siblings, to receive everything? Do we want things to go down to your grandkids from that child that predeceased you? Is there a charity that we want to benefit, maybe that that child had a special connection to? There are all kinds of different options, and we can really customize and specify the language. Or leaving money to an in-law, maybe the son-in-law or daughter-in-law that had married into the family has had a big impact on us, and we want to make sure that that person is included. Again, we can be really specific and we can be really detailed in the way that we handle that, but it's very difficult to include that specificity. In fact, it's impossible to include that specificity in something like a beneficiary designation or transfer on death deed. Estate taxes. Here's where I get to give a lot of people good news. The bad news is that there is a federal estate tax and there is a Minnesota estate tax. The good news is federal and Minnesota estate taxes don't kick in until a pretty high level of assets. The federal level of assets that's required before the federal estate tax kicks in is $13.99 million dollars. And that's scheduled to go up to $15 million next year. What does that mean? That means for your first $13.99 million, no estate tax is charged and no estate tax is due. But for your 13 millionth, 990,000 and first dollar, the federal estate tax starts to kick in, and they start that rate at 18%, going all the way up to a very high rate of tax at 40%. It's also important to know that the federal estate tax exemption is portable, meaning that if you're married, the surviving spouse between the two of you can pull forward the exemption that the first spouse, the deceased spouse, had at the time of their death. So we can actually effectively double that exemption amount if you're married. In Minnesota, the estate tax rate is lower. It starts at 13% and goes up to 16%, but the exemption is also significantly lower. That the Minnesota estate tax actually kicks in at $3 million. dollars. And it's more difficult to preserve a deceased spouse's exemption amount in Minnesota than it is under the federal rules. But it is possible when you write an estate plan in order to make sure that that happens. So again, if your total assets do not exceed $3 million, estate tax might not be an issue for you. But estate taxes aren't the primary, they're not the only reason to write an estate plan. Again, if you want to make sure that you're leaving a legacy of family harmony, a legacy that doesn't include conflict in your family that ends up tearing it apart, writing an estate plan is really important, whether estate taxes are an issue for you or not. And I want to caution everybody. Sometimes people think that they are wanting to give a gift to somebody who has different needs, somebody who's disabled, somebody who has some special needs about how they're being cared for. Oftentimes, somebody who has been determined to be disabled is receiving a government benefit that's helpful to them. The government benefit might be for their health care costs, it might be for their living costs or for their food. Whatever the case is, that government benefit can be interrupted by receiving a gift. That's just where I want to caution people that if you want to leave assets to somebody who might be receiving a government benefit, there are great ways to do that. But make sure that you're working with an estate planning attorney in order to accomplish that wish and not complicate that person's life and lead them into chaos of things changing and getting kicked off of the government benefit that they know and that has been so meaningful during their lifetime. So what should you do? We've talked about a lot of things here today. We've talked about how estate planning is really a gift that you can give to your family. And it's a gift that can make sure that your family is able to avoid conflict within itself, is able to maintain the harmony that you want your family to maintain if anything happens to you. We've talked about how important healthcare decisions are to communicate. We've talked about how you can avoid court procedures like conservatorship, guardianship, and probate. We've talked about estate taxes, and we've talked about so many different things today. And if something that I've talked about here tonight, maybe probate, it seems like probate tends to resonate a lot with people. And that time that probate takes, the cost that probate takes, the fact that it's a public process where things like an inventory of your assets get published, as well as who's receiving it, you may be asking yourself, what can I do? What can I do to get an estate plan written? And there's a couple ways that you can go about it. You can attempt to DIY your estate plan. DIY stands for do it yourself. Or you can hire an attorney. And keep in mind, not all attorneys are the same. Is it possible to DIY your estate plan? I would say that it's possible, but I would really caution you against it. Writing your own estate plan is like trying to put together IKEA furniture without the instructions. There are so many different pieces and parts, and they all need to fit in exactly the right way. And if you get any of those pieces or parts in the wrong place, the whole thing may just fall apart. Um, there's a story that I like to share as well about a DIY project where I failed. I had ordered new fishing poles for my son and I. I wanted to take my son fishing when he was really young. I think he was about 4 at the time. And I got these new fishing poles, and they had come without fishing line actually on the reels. Not a problem. I ordered some fishing line, and I brought them down to the basement, put them on a table, and started winding the fishing line on so that I'd be able to take my son fishing that same morning. When I went to snip the fishing line at the end after I had enough on the reel, I still don't know exactly what I did wrong. Maybe you do. But when I went to snip the line, all of a sudden the fishing line started jumping off of the reel, and I had this giant ball of tangled fishing line, similar to what you see on the screen in front of me. I share that story for this reason. That was a DIY project that I failed, but it was okay. I was able to recover from that failure pretty quickly. Number one, I was able to take care of it. I was able to clean up the mess. All I did was snip off the tangled fishing line, and I still had enough on the reel that I was able to take my son fishing that same morning. So I was able to fix it. I was able to fix it quickly. It probably cost me something like 30 cents a fishing line. Estate planning isn't like that. If you DIY your estate plan and it doesn't work the way that you intended it to, you aren't going to be there to fix the problems in your estate plan when they need to be fixed. And unfortunately, no fix is simple if an estate plan is broken. It's always going to require attorneys, it's always going to require court, and it's almost certainly going to lead to conflict in your family. I really encourage you, don't try and DIY your estate plan. Choose an attorney that's going to work for you. And I'll tell you, not every attorney is the same. With a typical estate planning attorney, you're going to get form documents that are kind of set it and forget it. You'll probably put them in the bottom of your desk or somewhere where you're not going to look at them anymore and figure, well, at least I got that checked off. But the reality is they may not work the way that you want them to in the future when you really need them to. The typical experience isn't going to keep money out of the Department of Unclaimed Property. Right now, there's something like $700 million dollars in the Minnesota Department of Unclaimed Property. And a big way that assets get there is that loved ones aren't aware of all of the assets that their deceased loved one had. And unfortunately, things get missed. Things like bank accounts, stock, retirement accounts, things get missed and they end up going to the Minnesota Department of Unclaimed Property instead of the beneficiaries, instead of the heirs that we really wanted them to go to. Working with a typical estate planning attorney may avoid probate, but it may not. Honestly, a lot of times, typical estate planning attorneys aren't really focused on it because probate is a second source of revenue that they can claim from their clients if their clients' estates end up having to go through probate. That's not the way that I operate. We'll talk about that in just a minute, but it's an unfortunate reality. Typical estate planning attorney doesn't keep the family out of conflict. Again, it's just not a focus a lot of times with a typical estate planning attorney. Typical estate planners going to leave assets to heirs unprotected with no ongoing legal guidance because they're going to charge hourly fees for your future needs. And it's going to create a wall between you and that estate planning attorney where you're not going to want to reach out to them and they're not going to want to reach out to you because everybody knows that it's going to have a cost. There's going to be a bill in the mail that comes after the fact when you're dealing with that situation. And if you have minor kids, a typical estate planner is not going to adequately protect those minor kids. And again, you're going to be left with this question. Is my plan going to work when I need it to work? And that's not a question that you should ever have after you've worked with an attorney to write an estate plan. Working with me is a totally different experience. I charge flat fees, and in fact, you will choose the fee that fits you and your finances and your family the absolute best. Typically, those fees range somewhere between $2,500 and $6,000, depending on what tools we're using in order to write your estate plan. But again, you're going to choose the fee that fits your family, your assets, and your finances best. And we'll help to counsel you through that process in order to make sure that it's a good fit. Planning it with us keeps the assets out of the Minnesota Department of Unclaimed Property. And that's really important, again, to make sure that things are going the way that you want things to go, that they're not going to be stuck with the Minnesota Department of Unclaimed Property. And we do that by creating an inventory of your assets that we're able to share with your beneficiaries and heirs after you're gone. Planning with us means that if you have minor kids, we can protect those kids totally, both in the short and immediate term, immediate situation, and in the long term. Planning with us means keeping your family out of court and conflict. And that's really at the heart of what I believe my role is as an estate planning attorney. I believe in being a peacemaker in families. I have seen families torn apart by fighting over estate plans and fighting over probate. And I hate to see it. It's not something that I ever want my clients to go through, which is why I take such a serious effort to make sure that we avoid court and conflict. Planning with me means knowing that you've made the right decisions. We don't just make the decisions for you, we bring you along in the process. We teach you what the actual laws are here in Minnesota. And we teach you exactly what Minnesota expects and what Minnesota would do in different situations. And then we coach you and counsel you to help you make the right decisions for your assets and for your family. Planning with us means that we can protect the family money from outsiders, and we can build in fantastic things like asset protection that are going to make sure that assets stay protected for the lifetime of your beneficiaries. Planning with us also means a lifetime of guidance and protection. We don't charge hourly fees, and our future communication regarding your plan is included in the package fee that we charge when we write your plan for you. You have a resource in us. You have a lifelong attorney that you can bring your questions to and make sure that you have complete understanding. And that's worth a significant amount. Most important thing is you know that your plan is going to work when your family needs it to work because you've worked with us to write it exactly the way that your family needs it to be written. So when you choose an attorney, I encourage you, choose an attorney that you know that you can rely on. I'm going to go ahead and post my link here in the chat. I do see that we have some questions, and I'm going to get to those in just a minute. But I want to encourage you to click on that link and look at my calendar because I want to make this really easy for you by giving you a couple of free gifts here today. The first gift is that I want to give you a session, a one-on-one session between the two of us called a family wealth planning session. That family wealth planning session has a $750 value because I set aside 2 hours of my time on my calendar in order to have this meeting with you. In this meeting, we're going to talk specifically, not generally like this webinar has been general information. We're going to talk specifically about your assets and the people that you love and exactly what would happen if something happened to you today. And we're going to explore different options and different tools that we have at our disposal that we can use in order to protect your things and your loved ones in the case that you become incapacitated or when you pass away. If it makes sense to continue and write a plan with us, great. If not, I feel comfortable knowing that you've had the information presented to you and specifics presented to you in a way that tells you exactly where you stand. But honestly, I've had people come to that family wealth planning session, and after I walk them through what it would mean for their family if something happened to them, they didn't really have any objections. They just said, that's okay. My family can figure it out if that's the case. If that's the case for you, that's going to be okay. That free session is truly complimentary. There's truly no obligation to continue and write an estate plan with us. Although you won't be surprised to hear most people do find that there's something that they want to change about the default plan and that there is something that they want to take care of and that they do want to work with us to help write a more comprehensive plan. If that's the case for you, there's another gift that I want to give you, and that gift is $250 off the estate planning package of your choice. And I want to give you that gift if you reserve your appointment before the end of the week here this week. Now, when you click on my calendar, you're going to see that there are no times available where you can actually meet with me before the end of the week. What I mean is, click on that link and grab some time out in December, or maybe it's January in the new year, that this is something you're going to check off your to-do list first thing in the new year. Take a look at your calendar and take a look at my calendar and find some time in order to take the next step and start this process. And I want you to do that before the end of the day on Saturday so that I can give you that $250 off the estate planning package of your choice. And I really encourage you to do this. So click on that link, take a look at my calendar, and get started. Make sure that you grab some time, even if we need to adjust that time, even if we need to find a different time. And I see somebody asking, where's the calendar link? I'm going to post it again here. It's also up on the screen. But go ahead and click on that. Click on Family Wealth Planning Session and find some time where you can come and meet with me. Even if we have to adjust the time that you choose, I really encourage you, click through, reserve some time with me so that we can have a deeper conversation. Our clients love working with us. And I'm not going to read through these reviews. Instead, I want to answer some questions that I see coming in. And I encourage you, if you haven't asked the questions that are on your mind yet, please bring those questions to me now. I love to answer questions, and so I'll be watching for those here. I see somebody asking, going back to the question about the power of attorney, do I do one for medical and one for financial, or is that only for financial and medical, and or is it only for financial and the medical is the healthcare agent? That's a great question. There are different forms. Typically, what I do is I have a power of attorney form that's going to be for legal and financial and tax matters. And I have a healthcare directive form that is going to name a healthcare agent. And it's also going to express your wishes for what kind of healthcare treatments you want to receive. Um, so the answer is I only do one power of attorney and one healthcare directive. But the healthcare directive that I write, the first part of that healthcare directive is sometimes called a medical power of attorney. The second part is sometimes called a living will. All of these terms are a little bit confusing, but suffice it to say, you're going to be covered. Your financial, legal, and tax matters are going to be covered. Your healthcare needs are going to be covered. Another question here, if you do a POA healthcare directive, transfer on death deed, and beneficiary designations on things like investment accounts and bank accounts, would you actually need an attorney if your estate is below the $3 million number? And my recommendation would be yes. I would still encourage you to work with an attorney. There are people who can get by without working with an attorney. I would say if your assets don't have a cumulative value of more than $75,000, there are some DIY options that maybe you could explore, and maybe you could make a run at writing your own estate plan. But if you really want to make sure that things go to the people that you want to receive them, and in the way that you want those people to receive, you're going to want to work with somebody who has understanding, who does this day in and day out, so that you know and have confidence that the plan that you've written is really going to have the effect that you want it to have. I have seen people DIY transfer on death deeds and get only a minor, simple little thing wrong. Somebody wrote on one transfer on death deed that I'm thinking about, they wrote lot 40 instead of lot 4. And the reason that they wrote lot 40 instead of lot 4 is because they copied and pasted the information over from the tax statement that they received. And unfortunately, there was an extra zero that was included when they copied that over. The effect of copying over that extra zero meant that the transfer on death deed was totally ineffective. And it meant that we actually had to go to court in order to ask a judge to fix the transfer on death deed and allow the property to transfer the way that the grantor, the way that the decedent, the person who had passed away, wanted the property to transfer. Luckily, the judge understood and saw things our way and was able to honor the transfer on death deed. But there were thousands of dollars of attorney's fees and months of waiting that were totally unnecessary in that situation. And in fact, if that person had come to me to write a transfer on death deed ahead of time, I could have written it for maybe one fifth the cost of maybe even less than one fifth the cost of what that ended up being. I see another question here. How often do you recommend updating a current trust? I don't recommend updating a current trust if the provisions in that trust are still doing what they ought to do. And so we look at things like, is the trustee that we have listed here still the person that you want to administer your trust if something happens to you? And we look at things like, are the distribution provisions still handled the way that you want the distributions to go? And we look at details and we look and make sure that things are still written the way that you want them to be. But I don't necessarily recommend updating the trust, but I recommend having that review and having that conversation every 3 years. I find that a 3-year review is really effective to make sure that we are keeping that trust funded the way that we want the trust to be funded, and that if there's anything that does change, that we're able to catch what has changed and make the adjustments that are needed in that 3-year review cycle. Another question here, do you help prepare an asset protection plan? Under what circumstances is that needed? Related to like Medicaid, it says Medicare, but Medicaid and nursing home care. And that's a great question. We all know that nursing home care is extraordinarily expensive. I'm seeing clients with bills that are $13,000 or $15,000 a month that are really quickly um, uh, spending down somebody's assets that they have spent their entire life saving and growing. So nursing home care costs are extraordinarily expensive. And that means that we really want help from the government in paying for us for those types of nursing home care costs as soon and as quickly as possible. And in order to get that care that care provided or that care subsidized, there are things that we can do in order to protect your assets and shelter your assets in specific ways, including things like asset protection planning and things like Medicaid asset protection trust, Medicaid asset protection planning. So it is something that I help with. There are circumstances where it's needed. It's difficult to go into all the details here today, But if it's something that you're concerned about, if it's something that's on your mind, those nursing home care costs and how they're going to get paid and what that's going to look like, I really encourage you to reach out to me, schedule a family wealth planning session, and we can talk about the specifics in your situation to make sure that we have a detailed plan for how that's going to work. Another question here. County clerk verified a transfer on death deed to ensure the right property info. Should you still be leery? Um, Here's what I recommend. Come in and meet with me, and I will do a complimentary review of that transfer on death deed for you. In the case that I was talking about, where the legal description was wrong, the abstractor, the county recorder, didn't have any problem actually recording the transfer on death deed that was submitted to the county recorder. They put that document into the county records without verifying that there was no lot 40, that there was only a lot 4. And the county clerks are not going to do any kind of verification on things like who the owner of the property is and if that's exactly detailed the right way. Sometimes they do, especially if it's registered as Torrance property. There's some more examination that they do. But there's no work that they do in order to make sure that the grantee beneficiaries, the people who are going to receive, are exactly the right people. And so I encourage you, if you've done a transfer on death deed and you want to make sure that it's going to have the effect that you want it to have, you can reach out to me and I'd be happy to look at it with you in the context of your complete estate plan as well. Another question here, for home to transfer directly to the person you desire, is listening in trust enough? And that's a good question. If you write a trust, we can be really specific and ensure that that home goes to the person that you want to receive it. And there are good ways to do that. There are many ways to do that. We can make sure that the person receives the home outright, or we can make sure that the person would receive things like the proceeds from the sale of the home. Um, uh, but yes, you can, through a trust, leave a home directly to an individual and make sure that that's going to be carried out. And then the trustee will have the responsibility for carrying out that provision after you're gone. Those are the major questions that I'm seeing here. I'm not seeing any other questions coming through right now. But again, I want to really encourage you to click on the link that I've provided a few times here. Scan the QR code on the screen if you prefer with your phone, or type in that URL that you see on the screen and book your free family wealth planning session. And I really encourage you to book that family wealth planning session here before the end of the day on Saturday, the end of the week here, so that you can get a 250 discount towards the estate planning package of your choice. I see somebody saying thank you for a great and informative session. Really appreciate the time. Thank you all for being here. Your spending time here this evening with me is really a gift that you're giving to your family. You care about your family and you want your family to have peace and to have harmony, even if something unexpected happens to you. And honestly, we all should expect that someday we are no longer going to be here. Someday we're going to pass away. But you, by being here and by taking the next step and getting a great estate plan written, can leave your family in peace and comfort for when that ultimately happens. You can avoid court and conflict in your family, and I would love to help. So thank you again for being here tonight. I hope that you all have a wonderful evening, and I hope that I get to speak with you soon. Thank you.